He's not the Messiah. He's a very naughty boy. What am I talking about? Dan's done a really good video, as always, about that MP asking for the reinstatement of blasphemy laws. But what I thought I'd do, being a non-controversial, no drama llama, is just to discuss blasphemy laws generally and just the history, because I thought you might find it vaguely interesting. It's funny about the Life of Brian thing, because I actually went to sort of Catholic school. And I've got an REA level and things, but ironically, all the priests there, they said, "Oh, you got to check this film out. It's really, really good." Because in the same way that Monty Python and the Holy Grail is considered to be a very accurate depiction of medieval life, they were saying this really goes to show what was happening in at the time with all the various groups, the Popular Front of Judea and the Judean Popular Front splitter. But anyway, to get back to it, in England and Wales, it used to be that blasphemy was part of canon law. The church had its own courts and its own set of laws and its own set of rules, which to a certain extent it still does. But the church had the power to punish both blasphemy and heresy, and there's always been a little bit of a sort of weird interface there as to which is which. And speaking of witches, it's a bit like when people say, "Oh, all these witches were burnt." Actually, nobody's ever burnt for witchcraft. Burning was the penalty for heresy. Witches were actually hanged. But yeah, so it started off as canon law because at the time the bishops, they said, well, we have jurisdiction to deal with all things relating to religion. So they could penalise the clergy. They could also penalise schoolmasters for spreading blasphemous things or heretical things. And they could also go after publishers of pamphlets. But later on, of course, the distinction between sort of church and state, notwithstanding we ended up with a established religion. It was actually Henry VIII, remember him, who sort of said, well, actually, this should be just part of secular law. Because he'd written something called the Six Articles when he was sucking up to the Protestants in Europe. And that was a sort of a series of technical things about, whether the Eucharist really turns into the body of Christ without substantiation, transubstantiation, and all that sort of thing. And he made it an offence to deny the Six Articles. And that was sort of the groundwork for how this became a common law offence, although there's also certain statutes, and like I say, it did all get rather complicated. But the first recorded case, as in the law reports, that was in 1676. That's something called Taylor's case. Now, it may be that there were other cases before then, because in those days, the law reports, people wrote them down. They were sort of pretty much handwritten. I mean, if you actually went to court, nowadays, it's quite simple. You just got a Westlaw or something and just print out all the relevant sort of case reports and statutes. But back in olden days, I'm going to have to do a like a bingo card of phrases I use a lot. You would send your clerk down to the law library with a list of, here, I want the extracts from these cases, and they would physically just handwrite them all out. So over time, obviously, we've lost some of the original law reports. But he was prosecuted, and the report contains the following passage. And Hale said that such kind of wicked, blasphemous words were not only offence to God and to religion, but a crime against the laws, state and government, and therefore punishable in this court. For to say religion is a cheat is to dissolve all those obligations whereby the civil societies are preserved, and Christianity is parcel of the laws of England, and therefore to reproach the Christian religion is to speak in subversion of the law. And this is something that we see coming a lot, where it's not so much that it's an attack on faith or an attack on religion, it's an attack on society as a whole. Because, at the time they would have said, we are a Christian society, so undermining the thing that binds us all together, because a lot of our laws are sort of based on Judeo-Christian precepts. I mean, obviously in America they have to keep all separation of church and state, separate. But, you got the Old Bailey, and there's a lovely mural. It's not actually in the public bit, unfortunately, but there's a lot of really nice mural of like interesting things in the law. So, they've got the signing of Magna Carta, But they've also got, the handing down of the Ten Commandments. And also, they've got Tenzing and Hillary on the top of Everest because it was painted in 1953. I quite like that. I'm not quite sure what that's got to do with the law. Another interesting thing at the Old Bailey is it's Britain's most bombed building. And every time it gets bombed and they clean up, they leave a little bit of bomb damage and shrapnel from the previous one. So if you go around, there's like, oh, there's a little bit from the war, there's a little bit from when Pyra were doing all this sort of thing. Honestly, if you ever get a chance to tour the Old Bailey, or the Central Criminal Court, as it really is its real name, I highly recommend it. There's an interesting case in 1841. A guy called Edward Moxton. He was found guilty of the publication of a blasphemous libel, which was a poem by Percy Shelley, because Shelley being a bit of a sort of, reprobate. So he'd done a public speaking of that, and he was actually sentenced to prison and condemned for 4 months. But the prosecution was actually brought, 'cause it was a private prosecution. Remember what I was saying about before, the CPS came in. But that was actually brought by a guy called Henry Hetherington, who himself had actually been prosecuted for blasphemous libel. And he wanted to test whether he'd been properly convicted, but rather appeal, he sort of said, well, I'll bring a prosecution and make a complete hash of it. And then hopefully they'll go, of course there's no such thing as blasphemous libel. They'll go, in that case, can I have my fine money back? Unfortunately, it didn't work, and the guy was convicted. But, there were sort of like various commissions on this sort of thing. And they said that, although the law forbade all denial of the being and providence of God and the Christian religion, it's only when irreligion assumes a form of an insult to God and man that the interference of the criminal law should take place. They said, if the decencies of controversy are observed, even the fundamentals of religion may be attacked without the writer being guilty of blasphemy. So the idea is, look, it's not challenging faith or anything like that as people move towards a sort of more rational society after, with the Reformation and, the Enlightenment. They said, look, okay, as long as you're nice about it, then of course you can have a go. But it was all this public order idea. It's like, if you start going out there and sort of whipping people up in a frenzy, we're just going to have loads of riots and fights. So it's not to protect God. Later on, there's a great quote actually from Denning, I think it was, who just sort of said, look, God's presumably powerful enough to take care of his own problems. The last person in Britain to be sent to prison for blasphemy was somebody called John Gott in 1921. He actually had 3 previous convictions, and he was prosecuted for publishing 2 pamphlets, Rib Ticklers or Questions for Parsons, and God and Gott. And it was a satirical take on sort of like Bible stories, and he compared Jesus to a clown. He got 9 months hard labour, despite the fact he had a very serious illness, and he died shortly afterwards. And that actually caused a lot of public outrage. A lot of people going, well, why are you doing this? Why are you sort of using the law to protect the church? And in 1949, just getting back to my notes, which looks suspiciously like the Wikipedia article, I must confess. But it's not entirely that. I did read a few more things, because I actually find this quite interesting. I'm very interested in sort of all things theological. But he said, blasphemy laws are a thing of the past. The reason for this law was because it was thought that a denial of Christianity was liable to shake the fabric of society, which itself was founded upon the Christian religion. There is no such danger to society now, and blasphemy is a dead letter. And there we thought, it's all gone to rest now, just say what you want. However, in 1979, Gay News published a poem, The Love That Dares Not Speak Its Name. And that was, and I'm doing actually this from memory, but that was basically a poem about, I think it was the Roman centurion at the crucifixion. And he was lamenting, the one, oh, what have we done, and all that sort of thing, and, the heavens have rended, and the veil in the temple tore, and all that sort of thing. But in that, he sort of comments on Jesus with a slight implication that he quite fancies him. And Mary Whitehouse brought a private prosecution for blasphemous libel. And he was convicted. Now, during the House of Lords appeal, Lord Scarman said, I do not subscribe to the view that the common law offence of blasphemous libel serves no useful purpose in law. The offence belongs to a group of criminal offences designed to safeguard the internal tranquillity of the kingdom. So he had resurrected this idea that actually blasphemy is a public order offence, because people will be outraged at all these sort of gay people implying this about Jesus, and there were cases that actually followed that and were approved. They actually referred to that case and said that's good law. Lord Scarman, he actually said, he was writing, actually he wrote this isn't in a judgment, this is just in a sort of legal journal. He said, every publication is said to be blasphemous which contains any contemptuous, reviling, scurrilous or ludicrous matter relating to God, Jesus or the Bible, or that formularies of the Church of England as by law established. It is not blasphemous to speak or publish opinions hostile to the Christian religion or to deny the existence of God, if the publication is couched in decent and temperate language. The test to be applied is as to the matter in which the doctrines are advocated and not as to the substance of the doctrines themselves. Everyone who publishes any blasphemous document is guilty of the offence of publishing a blasphemous libel. Everyone who speaks blasphemous words is guilty of the offence of blasphemy. Now, of course, now we have the Human Rights Act and Article 10. And it was believed that that effectively got rid of any of the last vestiges of sort of blasphemy. However, in a case, Wingrove in the UK, 1997, the court said it was within the margin of appreciation to restrict free speech in this way. So what's the margin of appreciation? The ECHR, the Convention on Human Rights, recognises that each country, even though they've all signed up to this common set of rules, they all have their slightly different ways of life and different ways of interpreting things. So the margin of appreciation says, well, look, we're not saying everybody has to do things the same way, and there's a range of reasonable things to do. So you can put restrictions on free speech, for instance. You can have laws about libel, or you can have laws about inciting sort of, bad behaviour and things like that, inciting criminality. And they said, okay, you can also have blasphemy laws, if they are reasonable, necessary and proportionate. And the mere fact that some countries say, well, we don't have those, doesn't mean other countries can't have those. I mean, that margin of appreciation applies to, all ECHR, all the European Convention on Human Rights, and it's recognised within the Human Rights Act itself. So there were sort of various other cases, and I won't go through them all. But an interesting one, to get back to sort of what actually brought this up, when what's his name, Salman Rushdie, published the Satanic Verses, somebody brought a private prosecution, saying, well, that was blasphemous. That was Crown and Chief Metropolitan Stipendiary Magistrate ex parte Chowdhury. But in that, the Divisional Court said the offence is blasphemy only protects Christianity, doesn't protect any other religion. And it was also held because somebody then brought an Article 9 challenge saying, well, I'm being treated differently, different religions are being treated differently. And Article 9 protects freedom of religion. And they said, well, no, it doesn't fall foul of that because of the unique fact. I mean, blasphemy always, even with attacks on Christianity, they said, well, it's only attacked on the Church of England version of Christianity because that's the established religion, and because we have this idea it's a public order thing, then that's why that has special protection. However, there were in 2008, Gordon Brown actually said, right, that's it. We are now going to abolish, and they abolished the offences of blasphemous libel and any other forms of blasphemy that were still lurking on the books, or common law offences. I mean, the tricky thing with common law is you can't really, it's always quite difficult to abolish a common law sort of concept. Although it can be done because, for instance, the Defamation Act 2013, that says the old common law defence known as the Reynolds defence is hereby abolished. So you can because statute always overrides common law and case law precedent. That's just the rule here. So Parliament can effectively pass any law they want to override either previous legislation or indeed any element of the common law. So as of 2008, there hasn't been any sort of blasphemy offence in this country. Although I think actually they only abolished it in Scotland about a year or two ago. Of course, that's not to say that attacks on religion that were couched in a way that stirred up, say, racial hatred couldn't be caught by other offences. But the idea is you can be as offensive as you want about religion, and you don't commit an offence. But obviously now, our Prime Minister has sort of hinted that he might be open to reintroducing that. I mean, it'd be interesting to see how they do it and how they formulate it, and undoubtedly there would be Article 10 challenges in the European Court of Human Rights. And the thing to remember about the ECHR is it's a living document. As they said at the time it was introduced, it is a floor, not a ceiling. And it's not unlike, the American Constitution, people say, the originalists say, well, it's frozen in time. It means what it means, and it means what it means all the time, forever. It hasn't changed. Whereas the ECHR specifically was written to say, look, as societies evolve and attitudes change, the way we interpret the convention and the way we interpret human rights will also change accordingly. And like I say, the idea is it's a floor, not a ceiling. So it was like, these are your base minimum rights now that can never be taken away, but it may be that over time we expand these. And the idea is that you should always end up with more rights as we go forward. So I think it could be argued that this is a bit of a retrograde step. And therefore, it wouldn't, even if it survived an ECH challenge in the past, maybe it wouldn't survive one today. But obviously, we will watch this space. But yeah, hope you found that vaguely interesting, vaguely useful, vaguely accurate. The boys are actually sat on their shelf at the moment and stuff. Because I didn't want them fighting about which side they go on. You know what they're like. But yeah, I'm away this weekend. I'm doing some advocacy training up in Bristol, so I'm really, really looking forward to that, because I always get inspired by all the young barristers, and luckily these are the pupils, so at least I might be able to teach them something. Because when I do the MPP course, the new practitioner course, where they've been on their feet for 3 years, they're just better than I am, so I just get stuck for something to say.